Good evening and welcome to the Scotch India Law Forum and LITFest organized under the aegis of the 82nd Scotch Summit. A young scholar in his early 20s, completing his PhD at Cambridge in England on the subject of emergency powers, could have only wondered where he would be using this applied learning. He could not have known that one day he would be involved in the rise and fall of multiple governments from Jharkhand and Uttarakhand to Goa, Karnataka, and Maharashtra. An animal lover and a lifelong practicing Jain, when he looked at Aslan, his Anatolian shepherd, a gift to his family and the love of his life, would have only wondered how certain age old practices could be conducted without inflicting cruelty upon animals. He could not have known that one day he would go to court against religious practices involving animal abuse, such as Jallikattu. A champion of free speech, equality, and gender equity, on seeing various discriminatory practices, could have only asked, is equity in this great nation only as long as the Chancellor's foot? He could not have known that one day he would advocate against age and gender related restrictions on offering prayers. A patriot could have only wondered why it should be a problem for anyone in this country to hoist the national flag. He could not have known that he would fight for a right to do so and emerge victorious in court. Dr. Abhishek Manu Singhvi is all this and more. Across a career spanning over 4 decades, Dr. Abhishek Manu Singhvi has had a ringside view of legal cases of seminal importance that have captured a great deal of national attention. In his magnum opus, Dr. Singhvi has given us a first-hand account of these cases from the trenches. This book makes for an excellent read from an insider's viewpoint on some of the most important legal questions that have been raised in India and helps the readers in understanding the intricacies of some of the most complex legal battles of our times. Dr. Singhvi is an eminent jurist, an author, and a parliamentarian, one of the senior most national spokespersons of the Congress Party, the youngest designated senior advocate, the youngest additional Solicitor General of India, and the youngest elected Vice President of the Supreme Court Bar Association. He was the chairman of the Parliamentary Committee on Law and the AICC Law and Human Rights Department. He's written popular fortnightly columns for the Hindustan Times, for the Times of India, educated at St. Columbus, Stephen's College in Delhi and Trinity College in Cambridge. He also has several publications to his credit. Ms. Mahua Moitra, Member of Parliament from the Lok Sabha, the Krishnanagar constituency in West Bengal. She has served as a member of the West Bengal Legislative Assembly representing Karimpur from 2016 to 2019 and has served as the General Secretary and National Spokesperson of the All India Trinamool Congress for the past few years. She was an investment banker before entering politics. Previously, she's been a member of the Standing Committee on Communications and Information Technology and Consultative Committee on the Ministry of Health and Family Welfare. Currently, she's also a member of the Joint Committee on the Personal Data Protection Bill 2019. Mr. Chandar Uday Singh, Senior Advocate, Supreme Court of India, in his illustrious career has appeared before the Supreme Court in the Navtej Singh Johar case as well as the Krishna Kumar Singh case that held the repeated promulgation of ordinances as unconstitutional. He's also the counsel for organizations such as Lawyers Collective and Citizens of Justice and Peace. He was previously a member of the Bombay Bar Association and practiced in the Bombay High Court for several years. Before turning to law, Mr. Singh was a journalist with the India Today Group. Mr. Satvik Verma, our moderator for this evening, senior advocate at the Delhi High Court. His areas of practice include corporate commercial litigation, shareholder and company disputes, breach of contract, and specific performance disputes. He also addresses telecom satellite law related litigation. He's regularly retained for disputes amongst the Commercial Courts Act, original suits including those related to IP law, connected to disparagement claims, copyright violation, advertising counsel matters. He's also briefed on white collar and related crimes. Given his vast experience, he advises and provides opinions on corporate legal strategy in relation to mergers and acquisitions, joint ventures, foreign direct investment, private equity placements, especially in relation to litigation exposure and risks, and is a self-confessed connoisseur of pocket squares. Mr. Verma, over to you.
Thanks, Rohan. Thank you. That's very generous of you. And thank you to the Scotch group, Mr. Samir Kochar, and Dr. Singhvi for giving me the opportunity to moderate this session. I'm truly excited. And so I would tell all our viewers to grab their beverages, perhaps get a bucket of popcorn and just sit back and relax because we're in for a great session today. We're of course discussing Dr. Singhvi's book. As I told him, Dr. Singhvi at the bar and in the profession is addressed as doctor or doc affectionately, and so that's how I will also be addressing him. Before we get into anything, Doc, from the trenches, I am very curious, as I'm sure the audience is, to understand on what prompted you to write this book, this collection of stories, and where did the idea, originate from?
Well, first of all, thanks very much, Rahul, for a very generous and I would imagine somewhat undeserved introduction. And thank you very much to my, and of course, Sameer is here. He's the father figure of this entire organization. Thanks to my colleagues, one in the bar, one in Parliament, Chandar and Mahua. And of course, Satvik, who's been the midwife, I would say, for this program and conceptualizing, he's pushed it. To be very honest, this is an idea which came from Chiki Sarkar of Jagannath, who has published it. And she just came to me one day. I didn't know her very well. I know her father better than her. And she said, look, you've been doing so many different kinds of cases. And I was once reading something in the papers, yet another case you did. And I thought, why don't you write something of your best choices of 10 odd cases, but make it more biased towards the layman, but also make it readable to the non-layman, the lawyer. I said, that's a very difficult remit, but it's an interesting thing, especially the bias towards the layman. And then the second and the most difficult thing about this book was not that, but was to choose 10. We ultimately settled on 8. That choice was really, really difficult because you've done so many interesting things you want to include. And of course, she provided me with a very competent young man, Mr. Satyajit Sarna, who used to sit with me on weekends. And I used to give him my written notes, my submissions, then discuss the case with him. And he would produce the draft. And the important thing was that he was able to do it in as layman a sense as possible, simple language and easy, so not jargon. So I think that is the story behind it. And the other thing was, when we discussed, I told him, I'd rather be anecdotal and tell you the story behind the story in each case. Sure. Not just the, A suit B and this happened.
I think you've achieved that brilliantly because, I was talking to both Mahua and Chandar before this session, and we'll let them make their opening remarks as well. As I said, we have no really rules or time-bound discussion. So everyone, this is going to be freewheeling. We'll go from conversation to conversation. But both Mahua and Chandar agreed that it's a very, very easy read. It's a page turner, and it breaks it down in simple words for the reader. So over to you, Mahua, and then Chandar for your opening remarks, and then we can jump right in.
Thank you. Thank you, Satvik. Hello, everyone. And thank you, Dr. Singhvi, for having me on this panel. It's really a pleasure to, I think what I like about this is it gave me a chance to read the book. And I have no sort of hesitation in admitting that I hadn't read the book before. You invited me to this panel, and actually, Mr. Kochhar sent it to me on Kindle, and I said, I'm not very good on Kindle. Can you send me a hard copy? So he sent me 2 hard copies. So, which is good because I put one in my bag and I kept one at home, and I managed to get through it very quickly. But what Satvik and I were discussing, and I think Mr. Singh also agreed with us, was that it is a very easy read. And if Chiki told you that the idea is to get cases in front, we grew up listening to the Nanavati case, right? When we grew up, you would listen to in Bengal, you had this Bhuval Sannyasi case where somebody was apparently injected with some kind of poison in the railway station. And you had the Nanavati case. So growing up in India, you had 1 or 2 cases that were these seminal cases that lay people grew up hearing about. But in the last 10 years or 15 years or 20 years, we have seen that there have been maybe 25, 30 such cases that have been seminal cases and milestones for our democracy, I would say. So for example, when Mr. Singh mentioned 377, that he had fought for, and Alan Grover had also been on that case. If I was reading through this book and there is a line in that, he says, he talks about, and what I like about the book is that he brings in very simple analogies that normal people with any sense of right and wrong, because what is common law based on is based on common sense. So it has to be something, a principle of law that intuitively appeals to a sort of reasonably educated human being. And if you think about it, and he's got this line in there in the J.S. Mill, he says the harm principle was J.S. Mill's Enlightenment era test for interference with personal liberty.
In short, that if I'm not harming anyone with my actions, I should be free to pursue them. Now, that is exactly the basic principle on which 377 was scored. That if you have sexual relations between two consenting adult males, then that is personal liberty. Who else is being harmed?
Sure.
Right? So this is, if I'm flying a flag, it's exactly the same thing.
Sure.
If it's the same
We'll
principle.
We'll come to the specifics. So
Later, sorry, okay.
Remarks,
so my opening remarks were that it's a fabulous book, and I'm glad I got the chance to read it. And I think it's something that should be, I think it should be part of a curriculum, or he should write another one for normal people to be able to read about the most famous cases in India in the last 10 years.
Excellent. And Chandra, we'll discuss the beautiful artwork behind you, all three of you. Dr. Singhvi has the beautiful Hussain and Raza. Mahua has some great caricatures and an elephant. And you've got the beautiful Tota Vaikuntams. So we'll discuss that offline. But your initial thoughts before we jump in?
So apart from the readability, which I think the collaboration that Manu has made with Jagannath and with Satyajit Sarna, I mean, it's amazing because for us lawyers to break things down, it's easy to break things down into very lucid arguments. You can even break them down into very, very brief arguments. You can make a 10-page submission into a 1-page submission, but it will still be legalese. What Manu has achieved with this book is to make it completely readable to the lay reader. So even a person who has little or no knowledge of the law is going to find the narrative, because I think he's picked the narrative behind the case rather than just the case itself. And that has made it, it's very compelling for the lay reader. But what strikes me here, and that's what I'd like to say in the opening remark, is Manu is known as one of the country's greatest commercial lawyers. And he's a commercial lawyer in both senses, as a master, absolute master of commercial law, and also known as one of the highest earning lawyers in the country. But when you look at the choice of 8 subjects here, you will find that they are evenly split between matters where he had a paying client and matters which he has done purely as on a pro bono basis for the love of the subject and for the need of the client and the country. I mean, like for instance, like DK Basu. DK Basu is one of the most amazing judgments, because it was a continuing mandamus which Manu has, I think, nursed for about 15 or 20 years or more, and which is still there. There are remnants of it still there, because the whole thing about videographing in police stations and all is still a live issue. The Sabarimala case was, of course, he had the Devasu on board, but it was still a very large public issue. And then the Santara case, the Ayaram Gayaram, and particularly the abuse of animals. All these are cases which stem from a lawyer who is willing to put aside his commercial interests and devote considerable time to matters of which he considers of moment and which are of great moment. So I think that is one of the defining things about this book, is it shows you that even the busiest commercial lawyer one of the busiest commercial lawyers in the country has this ability to focus on cases which have nothing to do with commerce and
Chandra, that's a great way of putting it, because some of the greatest compliment comes when your peer group and people at the same standing praise you. So Mr. Kapil Sibal addresses him for good reason as the lawyer with the Teflon touch. And he goes on to say that the cases that Dr. Singhvi has represented are clearly milestones in the legal history of our country. Fali Nariman, high praise from Fali Nariman, India's leading jurist, who says, from the trenches offers a first-hand account of a foot soldier engaged in the conflict. So without any further ado, I think let's all put our armor and delve straight into those cases and get a ringside view from the trenches. Doc, let's start with the Tata Press case, because I know there are certain cases that I would also like to focus on. We may not be able to in the time cover all 8, but the Tata Press case, it's a very interesting case for multiple reasons, because it bridges together exactly the 2 points that Chandra talked about. the premise of the case is with regard to the issues of freedom of speech and expression, but it is in the context of commercial speech and therefore commercial interests. And it is a case that has stood the test of time, as we all know. And it's also a case which has become the basis of the trademark law in our country, as most people would know. So, you know, it's also something you did early on, and how Aspichinoi almost accosted you in the corridors. Tell us, give us the trench view on this case.
Thanks for all the kind remarks. And I don't know to what extent Chandra was paying a compliment, or including a left-handed one. But I must clarify that somehow when you sit down to look at cases which you, because the most difficult is to select just 8. That was really a difficult job. I had about 18 in the first, 20 in the first list, and then made it to 15 and then 8. But it's interesting when you come down to the 8, the majority, barring 2, are all pro bono. Naveen Jindal, by the way, despite the name of the industrialist, is a pro bono flag case. So it is interesting intersection that you enjoy, that you really promote, is very likely to be pro bono. Now about Tata Press, I think for students of advocacy and law, it tells us how a little switch, which happened in an exchange between me and SP. SP is one of the leading lawyers of Mumbai, an extremely talented and a very good human being. But that small little idea, how it changed the law. Because today the bottom takeaway line is that under 19(1)(a), that is the free speech clause, till Tata Press, you excluded huge swathes of territory on the, I would say, somewhat superficial plea that this is commercial free speech, which is not protected. As if, you know, you could make that distinction between commercial and non-commercial free speech. So this was a great advance, and it happened because of that discussion we have at the corridor, where I said, you come up in a normal appeal on the rules of the MTNL. But why not let's challenge the larger issue? Why the hell should not commercial free speech be part of it? So we filed a writ, which goes direct to the Supreme Court and gets tagged with the SLP. The second thing about it was the robustness of Justice Kuldeep Singh, because he was ultimately in a division bench of 2 judges. So he had to do some acrobatics once we convinced him. And I was opposed by a formidable pair, Venugopal and Arun, the late lamented Arun Jaitley. And they cited Hamdard Dawakana, which was a much larger bench. Now, what turned the thing at some point in the case was when Kuldeep Singh suddenly felt that, look, we have been following Hamdard because Hamdard was following a US case.
Christensen, yes.
And that Christiansen, having been overruled in the country of its origin, why the hell should we be following at all something which the country of its origin has overruled? And I think that struck a sudden chord, and that was, the rest was easy to do. But the effect is very important. It allows a very large territory of addition, freedom of press, freedom of free speech, along with now, there is no real distinction by just flavoring it as commercial.
And thank you. And Mawa, hold your thoughts, but I do want to use that as just a stepping stool. You have a victory of sorts yesterday. You are one of the petitioners in the challenge to 124A sedition, which is also based on a US or on a UK legislation, and it's been abolished in the UK. So we'll come to that in just a minute. But before we go there, Chandar, given the fact that this Tata Press had an impact on commercial litigation in India, I was curious to know how much of foreign legislation continues to influence the decisions of our Supreme Court, because I know our Supreme Court cases are cited extensively in our neighboring countries, in Africa, in Australia, but here we were relying on a US legislation. And so I just thought your thoughts as a leading practitioner on the influence of foreign law on Indian jurisprudence.
So it's not, I wouldn't say the law, it's not the legislation, but the development of judgments, or the development of law by the interpretation and interpretation of common law principles. What has happened really is that all the old Commonwealth countries and countries like the United States and all, which are not Commonwealth, but they have the common law principles, barring the Napoleonic principles, which are mainly in mainland Europe. Practically a vast swath of the world, most of the world, I'm not very familiar about South America, but most of the rest of the world, the rest of the continents, follow the essential common law principles. So developments of law which flow from the development of common law are of great interest to every nation, and we as lawyers, we use that. So, and you know, as in fact, I think it was Justice Vineet Saran, who retired 2 days ago, who in his farewell speech said that we are only as good as the opposing teams that come up before us. As judges, we have, if we don't get great assistance from lawyers, we can't turn out decent judgments or good judgments. So we as lawyers use the developments of law all over the world. I mean, we're using constitutional court judgments from South Africa, we're using judgments from Australia, from Canada, etc. Not just commercial judgments, but constitutional law developments. In the Pegasus matter, there was extensive use. Every single person who was arguing Pegasus was relying on judgments from around the world. So now a judge who is looking for assistance on a particular issue, and you know, judges form prima facie views, and once they form a prima facie view, they want assistance, and very often they want assistance to further buttress the prima facie view which they feel is a view they would like to take. So when you give them great assistance from wherever it might be, the open-minded judges tend to grab at it, and that's how you get this interplay of law from different countries having an impact on, and it's the same with the Supreme Court of India.
And Mahua, you know, it's interesting because you're not a lawyer. You're in your second term as a parliamentarian. And indulge me, because in some ways you are a quasi-lawyer, because you've come back to court on more than a couple of occasions, asking for interference, whether it was the CSR or whether it is with your challenge to sedition. As a parliamentarian, given the argument of Dr. Singhvi that cut ice before the Supreme Court that, look, the basis of the law doesn't exist, what are your thoughts about the whole lawmaking procedure? Because, you know, we don't have and we don't witness the same kind of debates that one was witness to years ago. That's a separate conversation. I don't want to take this in the realm of politics, but purely as a lawmaker, what are your thoughts on something like this in the context of Tata Press, the impact it has on freedom of speech, and the larger issue on the development of jurisprudence?
You know, Dr. Singhvi is also in the Rajya Sabha, so he's also a lawmaker, as am I. And I don't want to sound too harsh about it, but what we are seeing, at least Dr. Singhvi has been there longer than I have. But what I've seen in my time, certainly in the Lok Sabha, is that the parliament has been reduced to being a rubber stamp. Now, it is obvious in a democracy, any party that has a group majority will obviously get the laws passed. That's not the point. But there has to be a reasoned debate about all the issues that are affecting the making of this law. And that is something, certainly in my time in parliament, that I have found to be completely lacking. So when you go, essentially, if you look at what, the job of the, and Dr. Singhvi, he talks about it very early on in the book. He says the job of the judiciary is not to make the law, which is to only make out if something is against our fundamental rights, is to strike that part down and to figure out, it's not to make the law. But when you look at something like, for example, sedition, and there are a lot of similarities with this, in that this was a 2-judge bench that Justice Singh sat on, and he was fighting against a 5-judge bench, and he didn't refer it. And he says, Dr. Singhvi writes, he says maybe he should have referred it, but he didn't. And the fact that the strategy of this, I found that fascinating, that, because very often as clients, as a political party, we've worked with Dr. Singhvi and continue to, and we work with lawyers all the time, and we sit there and we try and figure out strategies. And this strategy where you go with the SLP, and we've often done that. So for example, somebody else will go for state of West Bengal, and Dr. Singhvi will go for me, or what I'm saying? We divide it up so that every part of the argument is presented. And that kind of holistic approach really worked well here. And one other thing which I found here, it says that you have a right to not only say it, but a right to be heard. It is someone's right to hear what someone else has to say.
Sure.
And that's a principle that I think is totally missing from any kind of lawmaking today.
So I actually lament that.
Thank you. And what's really missing also as we move ahead to DK Basu, for the audience who may not know, DK Basu is a former judge of the Calcutta High Court. He had sent a letter to the then Chief Justice as regards the plights and human rights of under trial prisoners and the torture that they face. This is, for me, and I'm sure for Dr. Singhvi, and we'll hear his thoughts on it, this is really a seminal case and a big one in Dr. Singhvi's career, amongst the many other glories that he has. For the audience to break it down, if you've ever entered a police station, there is often, there is always a board that is mandated in law for a prisoner to be informed about his rights. And that is courtesy what Dr. Singhvi put together as amicus. An amicus curiae is a friend of the court who provides a neutral view about a matter that the court is grappling with. This was in your 5th year at the bar when you had just come in.
This was a big case, a non-paying big case for more than one reason. Few people know that Chinnappa Reddy was a card-holding communist judge. He used to hold a Communist Party card. Of course, he completely divorced himself from any political party after getting onto the bench. And as I've said in the book, he was totally, not knowingly at all, took a liking to me because I represented that Teja Singh, who was a completely forlorn, destitute man. But the important takeaway, to be very brief about DK Basu, was that we have now a charter of rights in 3 DK Basus, DK1, DK2 and DK3. But apart from that, we have an innumerable number of interim orders. And they've had this charter of rights, what I called in my first written submissions, the 10 commandments. And then now they've become 15 or 17. We now have the CCTV expansion. But when the matter, Justice Chinnappa Reddy, although he started it, didn't really go on the bench too long to conduct it. But the person who heard the bulk of it was Justice A.S. Anand's bench. And what we grappled with, and what I told him in the first hearing, until the end, we've not found an answer, is that we can make all the rights we want. And we made many improvements. I'm not saying a lot of these are not very valuable, but ultimately, and I said this is the first hearing 40 years ago, I said, how do you decide the point of arrest? That's the dilemma.
Very right.
All the rights of Mahua Mitra start applying from that blackboard after she's arrested, and that arrest is shown as an official arrest.
Sure.
The problem is that she's arrested 2 days ago unofficially and shown to be arrested today. Then in the interregnum of 48 hours, those rights don't apply. Now we were struggling, and I'm still struggling to find an answer to that. There is no real answer, except that you crib and cramp the police in a manner that it becomes difficult to do so. So you have information to the next of kin, you have all the name tags, you have, of course, so many other things. Now, of course, CCTV, which is a very important improvement. But I think it has something which is the most classic continuing mandamus structure. It is not something which can ever end. And one of these days, I'll collect all the vices and maybe make a DK Basu 4. Because I continue to be, in that sense, a continuing mandamus.
And Mahua, as I was preparing for this, I thought that you are a absolutely right person to comment on this, right? Because constituency, people on the ground, people who are perhaps subjected to this, right? People who are probably hauled up into police stations, who are frantically calling you saying, madam, this has happened. So while, and Dr. Singhvi alluded to it, but while we have this continuing mandamus, and we have a set of regulations, which by the way exist even post the Vinod Dua in sedition or Asim Trivedi, on the ground, will you please share for our audience that on the ground, a DK Basu, what is the impact that it has and the benefit that it provides to people? Sorry, sir, go ahead.
We tend to be skeptical, rightly critical, but we have walked many miles.
Absolutely.
But equally, there are many, many more miles to walk still. I think in terms of awareness of people of their rights, a certain amount of fear in the police, the fact that they are accountable, all that is humongously increased. And it's an ongoing process. I've had budgets allocated for police stations and such centers. Otherwise, they would simply say we don't have the money. But the two areas where there's a problem is we still haven't solved the problem of how to compel the showing of the arrest at the right time when you're actually arresting. And if anybody has any ideas, I'd be very happy to receive them sometime. Second, the one area which is failed, I've given statistics in my submissions. Police officials are still woefully inadequately punished by the two processes which they alone fear. One is departmental action, suspension followed by dismissal. Second is criminal prosecution. If you see the charts, I've given state-wise charts in the pleadings there. It is abysmally low. It's an infinitesimal fraction of the percentage it should be. And unless you instill that some degree of fear, there is going to be no deterrence. That's my real regret, and maybe we'll push more in that direction in the future.
And absolutely, Doc. I don't think, I think we've galloped. We have really covered a lot of ground. And, it's an evolving process. It's not something we can achieve overnight, especially in a country like ours. But, not as a critique, but really as a reality check, Mahua. What is it like on the ground?
It's almost, I would say, I don't know, it's apt and it's almost unreal that while I was listening to you speak about this, I was just thinking of something that happened 2 weeks ago. And I agree with Dr. Singhvi that when he says, when CCTV cameras are there, they may be put the wrong way, but it's a step in the right direction. And I have a rural constituency. It's 220 kilometers of unfenced border with Bangladesh. And Murshidabad on one side is Bangladesh. It's a riverine border, hasn't yet been fenced. So there's nothing that doesn't go on there, right? And it's a completely rural agrarian economy. And there are only SHOs, only one district, one big police station. So when we talk about the point of arrest, that is my government, I'm not trying to speak from the point of view of a legislator, point of view of a lawmaker, or having been in government in the state. Even 2 weeks ago, 66A has gone from the statute books, right? Somebody put up a Facebook post that the current MLA, one of mine, didn't like. So what do? There's no 66A to prosecute. So you call up the local police, the local SHO, as we call the OC or the IC, the officer in charge, and you say, usko zara dhamka. So what does the OC do? Goes there, picks the guy up, and I'm saying this in record, picks the guy up, brings him to the police station. Now, what is today's checks and balance, this eternal vigilance today is, funnily enough, the mobile phone. Right? So when he's picked up from the house, it used to be even in 2008 when I entered politics that we would not know that he's been picked up 5 o'clock or 7 o'clock. Today, when he was picked up, he's taken to the police station. They've done nothing to him. They've made him sit there from morning till evening. So when these people called me and said, I called up the SP, I didn't call the OC, and I said, so-and-so's been sitting there from the morning, what's happened? The SP writes to me on WhatsApp. This is an SP writing to a member of parliament of the ruling party, and she puts down in black and white. She says, he has been placed under arrest, man, under section X, Y, and Z. Inciting communal hatred, blah, blah, blah. So I looked at it and I said, madam, if that isn't, if the whatever he's arrested for doesn't follow that, is that really the case? For whatever reason, the SHO and the SP kind of realized that they were on the wrong side of me. I'm in the ruling party. Please understand. 15 minutes later, the SHO lets the guy go and says he wasn't arrested. We had just kept him there to talk. The SP then writes to me and says, we hadn't arrested him. The OC had informed me wrongly. I said, what's the system here? We quoted the sections and told me under which he was arrested. So was the SHO lying to the SP or was the SP lying to the MP? Right. So this is the question. So look at the lacunae. I remember Jay Galla, who's with us in parliament, was picked up and taken around in a car for something like 16 hours. There was another TDP person who was head of the TDP. This happened 2 years ago, who had just had an operation for hemorrhoids. And he'd come back from the hospital 2 days ago. And he was picked up by the Andhra Pradesh police, put in the back of a car and moving around for 8 hours. And he was bleeding at the end of it. So where is the point of arrest? I agree with Dr. Singhvi that this is something we face every day. And I struggle to think as to what, there has to be some kind of stronger penal provision for erring police officers, because every state government controls their own police and we are equally at fault. Sure. But every state government controls their own police and,
And Chandar, as someone who's so, you have a thriving commercial practice, but you're also a public spirited lawyer who does so much on civil rights. Any thoughts before we move into what I think is the the big moment
Yeah,
of
let
the
me-
discussion, Sabarimala and Santara.
Okay, let me just very quickly in a few sentences say what I think where one of the aspects which we tend to sort of gloss over is the attitude of the courts. The fact is that you scratch the skin of 10 judges and probably 8 out of them or 9 out of them will condone these sort of tactics of delaying arrest, etc. And they will even condone, and sadly I've heard judges say this, they even condone torture. They laugh about torture. They trivialize it. And we are not a signatory to the Torture Convention, but we were the main formulators of the Universal Declaration of Human Rights in 1948. When we were making our own fundamental rights chapter in the Constituent Assembly, we were simultaneously, Hansa Mehta and a whole delegation of ours was working on the Universal Declaration, which clearly has provisions against torture. But torture is rampant. It's rife. It's in every state. It doesn't matter whether it's a state ruled by X or Y or Z party. The police are brutal. We are a brutalized society. And the sad thing is that the judges don't take it seriously. The judges scoff at it or think it's just part of the scene or think that you can't do crime investigation without torture. Most of them believe this. And this is the sad thing. And this goes all the way up to the top of our judiciary. So I think unless we change our attitudes, because it is the judiciary ultimately which can crack the whip. D.K. Basu is the judiciary standing up and being counted. But then the next judge and the next judge and the next judge have to see that that gets implemented on the ground. So when a complaint comes to them, this Faizan, who was killed in the Delhi riots, he was there. He had been shot. He had a bullet in him, and they were prodding him with lathis, hitting him and making him sing the national anthem. It's on video. It's everywhere. And nothing has been done. He died the next day, and what they do is just before he's dying, they release him to the family and say he didn't die in custody. Now, this is how this is videographed, and no judge, no court takes it seriously. So unless we change our attitudes in the judiciary, I don't think we are going to overcome this.
And thank you, because you make my job. I think those are very telling comments. Those are also, they're giving me goosebumps of kinds, because it is reflection of our society. But you've also made my job easy, because I'm going to move on and I am going to discuss the Sabarimala and the Santara case somewhat collectively. But, I'm picking on what you said, Chandar, with regard to how it falls into the hands of certain judges. And let me quote from Dr. Singhvi's book in the context of the Sabarimala case, where he says that the concept of constitutional morality had been expanded. And he says the Constitution has a certain moral framework of fairness, equality, and freedom built into it, which permits the court to interpret the law in such a way as to amplify those views. But he also goes on to say that if this concept of morality falls in the hands of a wrong judge, then it can mean something completely different. So, Doc, your opening comments on this, because I have a lot that I'd like to put out there for the audience, and to have the three of you engage with the audience on this. We've already started getting a lot of questions, which I'll save for the end. But Sabarimala, Santara, essential religious practice, please.
I'd rather the others commented more, because these are very personal cases I've lived through. I want to make quick, sharp, short comments to save time. There are cases which come to you where your initial reaction is just the opposite. I almost didn't want to accept Sabarimala because my reaction, like most people, was, and I believe very strongly as a lawyer that you can't choose your clients and you should not judge your clients, except that you cannot cross legal boundaries, but you should not be judging your clients all the time. So it's not a brief, not only because it's a very unpopular brief, but because the first blush reaction was against the brief I was holding, which is exclusion of women. But the compensatory fun of this case was that it was an extraordinarily interesting journey in constitutional law. because we had to craft, in an unpopular case, to craft a constitutionally reasonable structure. And to take just 2 minutes very quickly, otherwise it's complicated. We said that you have to actually work out the Article 14 classification to see whether there is a reasonable nexus with the concept of the entity involved. And if this is the only out of 1500 temples, the only one in India which has the Nashtika eternal brahmacharya image of the god, then you have to examine whether that image of the eternal brahmacharya, the Nashtik brahmacharya, has a link with the classification. The classification being all men, yes, less than 10 and above 50 women, yes, but 10 to 50 women, no. The second point of Article 14 was that this is not a men-woman classification. It's a men plus some women versus some other women classification. So this was a very, very abstract, purely legal one. And of course, it had many remarkable, it was heard at great length. It is now not closed because it is open now on review. It is pending. It is pending. It had the lone dissenter as a woman in that matter. And there were very interesting and fascinating excursions into the history and the origin of the Nashtik Brahmacharya Kartike. Also, you will be astonished to know that when they asked, we did actually file them, and I'll end on this because I don't want to take too much time. The overwhelming number of thousands of affidavits, which of course we did not want to burden the court with. In fact, I would say lakhs, were of women who supported my stand. Now, these are the interesting things about India. Now, that doesn't mean a value judgment. There is a lot to be said for non-exclusion. My case was simply in one sentence. This one temple has a unique origin, and that exclusion has a direct link with the nature of the deity. And the deity, if it undoubtedly is an essential religious practice of Hinduism, it is believed in genuinely, well, then Article 25 protects it. The moment it is genuine and is believed in, then you can't question too much, the rationality. After all, people cannot violate temple rules in so many other respects in terms of time and, rituals.
And
I'm not at all suggesting that people should agree with me on that.
Mahua, I'm going to throw this open to you, but let me just provide a baseline on which you can comment. A couple of things from Dr. Singhvi's book that really got me thinking. So he says that religion by nature is opposed to progressive belief. He also says in his book that there is a bit of a dichotomy on the issue of judges in a secular country deciding on religious issues. He says this in the context of Sabarimala. And then in the context of Shantara, he very brilliantly says, and both for the audience, both of the cases dealt with the concept and principle of essential religious practice. But in Shantara, he says something again on page 122 that I like, which says, sometimes when the court enters questions of religion, sometimes the results may not be rational or which seem rational to the outsider, but cause anger in that particular religious community. So, here it was where in Shantara, he was defending the Jain tradition of it being an essential religious practice. And in the other, he was opposing the rights. He talked about the lone dissenting woman, Justice Indu Malhotra, and your thoughts, Mahua, and then Chandar, please feel free to jump in.
I actually think that Dr. Singhvi in both these cases was on the same side. So in Shantara, he's talking about the right of the person as an essential religious practice to choose this path for himself, and it is not suicide. In also the Sabarimala, he was for the Viswam board, which, he agrees with Indu Malhotra's thing where she says that this is an essential religious practice and it is an identity. The thing is an identity. So I think he's on the same side there. What I have an issue with, and this is, which I don't agree with, and the good news, the good part about this chapter about Sabarimala, it lays out both sides, and it really makes people think, and it made me think. Now, when Dr. Singhvi says there are lakhs of affidavits about women who are in between the ages of 10 and 50, who say that we don't have a problem with not going to the temple.
believe me, and I have done this as at the grassroots level, that even till today in Hindu houses, menstruating women are not allowed in the kitchen and in the puja. Now, if you were to take a straw poll of, say, 10 lakh Hindu women in my constituency or anywhere for that matter, 8 or 9 lakh out of them will say, yes, we agree with it. There would be 1 lakh that would say, we don't. So the fact that we have a lakh affidavits or whatever saying that this is actually may not have anything to do with, with it being an essential realized within practice, religion, the very nature of it is opposed to rationality. It is. You believe in something because you believe. I wear this because I believe that it is protecting me from evil. Somebody else might think it's a piece of gold on a piece of thread. There is no sense to that, right? So I understand that. But the point is not that. The point is in this, and it brings it out. What I like about the chapter is that he's saying, look, I am hired by X. I am going to present the view of X.
Oh, absolutely.
That's not to say there's something wrong with the point of view of Y, and he's brought that across.
I didn't.
Okay, so in my case, actually reading the chapter made me even more surer of being on the opposite side, because for me, it was very clear that Ayappa has been defined in a patriarchal world as this Brahmanical, as this brahmachari deity. I or women had nothing to do in its definition, because by nature, a patriarchal system that laid it down. So if I'm a woman between the age of 10 and 50, I may also want to worship Ayappa. And I may want to do that. It is not the same as going to a temple when the god is sleeping, because that rule is applicable to men, women, any worshipper at a temple. It is an equal opportunity exclusion, if I may say so. But over here, it is not an equal opportunity exclusion, because I may want to see the deity. I may think that the deity has appeared to me in a dream. And as part of my religion, that is stopped. That is open to me. So I think as a fundamental right, that's not to say that women between the age of 10 and 50 should be denied that right. So I do believe the principle of discrimination or exclusion applied in this case. So I actually go with the other side. But what I like about this is, these are obviously very complex religious issues, is that by reading this, it's almost as if, it's not as though written from Dr. Singhvi's point of view, it lays both sides, which I think any good book should do.
And Chandar, your thoughts? Because, let me clarify. I don't think Dr. Singhvi was not on the same side. I agree with Mahua. And we're not really discussing his brief, as it were, but just the impact that it had on the larger constitutional jurisprudence in the country.
So I want to focus on a slightly different
yes, please, by all means.
What Manu says in the Sabarimala, in his chapter on Sabarimala is very important. He says that these issues ought not to be decided on in writ petitions or PILs, because these are issues which require evidence, and they require normally they should be tried as suits where actual evidence can be led. Now, actually, what is missed in Sabarimala, and this goes beyond Manu's chapter and the entire case, is that Sabarimala was actually, women were going there, women of menstruating age were going there. In 1990, a chap called Mahendran wrote a letter to Justice Paripurnan of the Kerala High Court and said, why are women being allowed there? This is an age-old temple, they ought not to be allowed there. And he says, according to him, there was a custom earlier that women were not allowed to go. And what Paripurnan did was, he treated that letter as a PIL in the Kerala High Court, and he, presiding over a bench, then invited people to bring in, to file affidavits. There was a Chandrika, that Mrs. Chandrika was the secretary of the Kerala Devaswam Board. She was an IAS officer. She had taken her daughter for the rice feeding ceremony of her grandchild. The first when you wean a child, you give them rice, and they used to take them to Sabarimala. Now, because the child was taken to Sabarimala for giving that rice, automatically the mother was always there, and the mother was obviously of menstruating age, right? And this was a tradition. Chandrika filed an affidavit to that effect, these had been reported in Janmabhoomi and all. Mahendran said, why is this happening? Why is this getting reported in the press? Why are all these women trekking? Why are women being allowed to trek to Sabarimala? And it was in that PIL that the Kerala High Court, by inviting affidavits from various priests and then said, these priests say this is an age-old tradition and therefore it should not be allowed. So it was by a judgment of the Kerala High Court that women were barred from coming in 1991. It's a reported judgment, the Mahendran versus Kerala Devaswam Board. This whole thing was lost sight of in the Supreme Court because, as Manu rightly says, these are not issues which should be decided on affidavit, neither in Mahendran's case in 1991 nor in the Supreme Court in 2017 or 18 or whenever. They ought to be decided on actual evidence. What is the tradition? What is the belief? What is etc. 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 And Manu is right. Beliefs are by their very nature, and they're not logical. They're not rational. What you believe is what you believe. But so I'm only on the process. I think he hits the nail on the head when he says the process here, though it came to a particular result, and though it's now been referred to a larger bench, and this whole issue of essential religious practices will be gone into. But the process actually ought not to start as a writ petition or a PIL. These are matters which should be decided on the basis, even the belief must be proved by cogent evidence and tested on cross-examination.
And
Couple of sentences, Satvik. It's very important what Chandar said. By the time the matter reaches the Supreme Court, the judges are so taken up with the great aura of the matter sometimes. The press adds a lot of fuel to the cocktail that nobody wants to go into these petty, issues. These are considered, what Chandra said, something which should be brushed. Let's go to the jugular and decide the larger issue. There is a whole section in my written submissions attaching Mahendran, and one of our principal arguments, Chandar, was that you need not go into any of this, just dispose it off and let the courts decide below. That was ignored completely because it was too sensational a matter and too high profile a matter. Everybody wants to be part of that high profile sensationalism. And that's why this important part of the process, which is very strongly taken, is ignored completely.
And Doc, I am going to come to the issue, sorry, Chandra, I am going to come to the issue of the impact, because I think both in the Jallikattu case and in the Sabarimala case, you talk about the role of the media. So I'm going to save that question for a little later. We're 10 minutes to 7, but I want to come back, Doc, to what Chandra said, because I completely and wholeheartedly agree with him that it appears, and it's quite evident, rather not appears, it's very evident from your book that there is a connecting theme. You were pained about the fact that Sabarimala was a case that was not filed by women who were prevented, but by someone else. You were pained that the Santhara case was filed by Nikhil Soni in the context of 3 people separately. You mentioned in Jallikattu also that it started off as a writ petition. But for the audience, and we're getting a lot of questions with regard to DK Basu, but for the audience, Doc, DK Basu was also a PIL. So how do you harmonize, to use an expression from your book, or juxtapose the advantages of a PIL in DK Basu versus PIL being used for the other cases?
You see, it depends on the nature of the subject and the nature of the PIL. DK Basu is something which is not targeted at a particular institution or a particular body or a particular activity in the narrower sense. It is about reform in police stations, and that is amenable, in fact, ideally amenable to PIL. The categories of both Santhara and Sabarimala, and to an extent even the category of Jallikattu, or the process which Chandar mentions. The problem there is that the person who should be actually the petitioner becomes the respondent. A third party files a PIL. The rights which are to be asserted of Article 25, the right to religion, etc., are being asserted by a respondent. Normally, it is the petitioner who will assert those rights. And this is a dichotomy which people don't, that's the Mahendra Raj thing, that's the PIL format. So that you become a respondent trying to assert a 25 right, whereas actually the burden of proof should be on me to file and say, I am an Article 25 petitioner, I will discharge that burden. Whole thing gets upside down. That's a technical answer, but that's the correct answer. Secondly, I think both Jallikattu and the other 2 matters they just involved a broad brush look at the provisions. They did not involve any evidence of any kind at all. DK Basu doesn't need evidence, it requires statistical data. But these other matters required some degree of evidence, which was just absent completely.
Go ahead, Mawa. Go ahead, please. Yeah.
I agree with you, but I think that this is something that the today's judiciary does not appreciate, because I'll tell you, and I think Mr. Singh will back me up on this, because I had written, DK Basu was a letter petition, epistolary jurisdiction, as you call it, and I had written a letter petition in March 2020 to the Chief Justice of India, saying that there are all these migrants on the road, and can the courts please intervene? And I think to humor me, the then Chief Justice agreed to hear it. And he heard it, and I said I'd represent myself, and the Solicitor General was on the other side, and the Solicitor General stood up and in court, and he said, you know, this is all rubbish. What does she know about this? This is just rubbish. And as of whatever time, there is nobody on the streets. And it was, I mean, I was crazy that, I think Mr. Singh also knows this, it was crazy that then Chief Justice turned a blind eye to it and accepted the fact that as of Tuesday, 10 a.m., that there was nobody on the streets. And to me, if DK Basu was reason for a letter petition to be converted to a PIL, then there is no better, by that same logic, no better example of the migrant issue in March 2020 to be converted to a PIL for the same reason. Do you agree, Mr. Singh? Or Doc?
Yes, I think I agree with both you and Manu. See, what I think the distinction Manu is drawing is that where human rights are involved, and human rights, not human rights vis-a-vis an institution like a temple which says that I've got some ancient history of XYZ or whatever. But where human rights in general, like torture, like people losing their lives on the streets in the migrant crisis, like starvation deaths, or even things like illegal sand mining, illegal destruction of forests and mountains and so on. These are matters which I think need to be decided in PIL, because there cannot be a suit. If you were to file a civil suit, who's going to file the civil suit? Who's going to prosecute it? Who will pay the court fees, etc., etc.? There's a whole host of things. On the other hand, there are certain cases which require evidence. Now, it's not that in a PIL you can't have evidence. Theoretically, even the Supreme Court can record evidence, the High Court can record evidence. But that's in theory. With their time constraints, they don't, and they go by affidavit. And then what happens is this sort of thing of who should be the plaintiff, who should be the petitioner, and who should be the respondent. Now, should the institution now be defending itself? Now, you know, there's a natural tendency to say, why were women being excluded from the sanctum sanctorum of Haji Ali? Everybody. I don't think I'd find a single person who would say that the Bombay High Court was wrong in saying that they must be allowed into the sanctum sanctorum. On what basis are you doing this? But who knows if evidence had been taken, what was the ancient history, what was this, what is the Islamic belief, etc., etc., etc. I don't know. But emotionally, emotively, for me, Sabarimala, the Haji Ali case, etc., etc., these are just, it's like a given. For a person like me, it's like a no-brainer. It has to be done. For the institution, it might be a very, very serious case. And look, this completely violates our fundamental beliefs. So yes, you have a fundamental right. I have a fundamental belief. How should the two be weighed, and how should you find out? So that's, I think that's somewhere there would have to be a line drawn.
And Chandra, I love the direction this is taking, because, you know, my job as a moderator is really to get the three of you to speak. I'm not sharing my personal views here, right? I want to play Narad Muni. I want this discussion to get a little more, have a little more histrionics. But, you know, when you say, and we have a question that's been put to us, whether the court should even be going into the essential religious practice. You know, there was something Mahua said, and you responded, but the issue of women is also a larger issue of reform, because the issue of providing women equal treatment is something that's very critical to the stage that we find ourselves in our current democracy. So I believe fundamentally, I think no one on this panel would disagree, with a right-thinking mind that women need to be treated equally. The situation on the ground is very different. Mahua mentioned about, menstruating women not being allowed. Dr. Singhvi talks about it in his book. And yet it's about the empowerment of women. So I agree with the procedural aspect, but let's just put that away, because yes, there is a, but let's just look at the larger benefit that it has on society. So your thoughts, and then Doc, perhaps you, because we have a pressing couple of questions. So Chandar, quickly, do you want to respond before we move on to Doc?
No, I'm going to pass that to Manu.
Well, I think just in the shortness of time, I think it is important to realize that Article 25 to 28 and 29, that bunch of articles, the heart and soul is the protection of your religious rights. Now, the moment you go there, a lot of other things have to give way, provided you are squarely embedded within that class of 25, 26, 27, 28, etc. And the triple test there, of course, barring a larger issue, which I'm also arguing in a whole bunch of cases, Sabarimala, the Dawoodi Bohra case and all that, the triple test is the test which has to be there, and other rights will have to give way. A, is there a religion and a religious belief involved? That's question one. B, is if that is, then the act or the activity, is it an essential part? Now there's a whole separate line where people are saying, and I myself are arguing, that essentiality should be done away as a test. But for the moment, the law is the activity complained of part of that religious practice? Is it an essential part of it? And third is, if these two are met, then the right must fructify to a full ripened tree, barring only those 2 or 3 derogations of public order, morality, etc. Then you can't say, look, I think this is not progressive. I think the fact that Chandar wears his turban the other way around is not progressive, it looks bad. I think the way Mahua covers her head is just, it shocks my conscience. It's unequal. It just doesn't work, because that's the whole antithesis of 25, 26, but provided A, it is a genuinely held religious belief or part of a denomination, which is, for example, the famous case of Anand Margis from Calcutta is the best example. The Anand Margis said, we are A, Hindu, B, our essential practice is that we must have a Tandav Nritya down the streets of Calcutta along with a Trishul. So the police commissioner said, I won't allow a Trishul. So they filed a case.
And the skull.
And a skull. So the court said, A, a skull and a Trishul and all these are not essential part anyway. B, the Anand Marg itself is not a religion denomination recognized as part of the separate Hindu denomination. Now, once the question is, once you're part of these two tests, then a lot of other, I mean, I'm actually shocked by some very regressive practices. But the word regression doesn't apply the moment you have 25, 26 kicking in. That's the whole issue which people tend to forget. This whole set of rights was put to protect those practices, irrespective of your subjective anger or revulsion at them.
And Mahua, before we get into a question, just to ease things up a little bit, did you as a child ever see one of these processions in Calcutta? Did you have sleepless nights with these cars?
I didn't see one as a child, but it was, we kept talking about this Ananda Margi Lake Gardens. There's a bridge in Calcutta where some Ananda Margis had been shot, and till the late 80s, every time we passed that bridge, people would talk about this. So yes, I did grow up in the shadow of this, even if I didn't see it. But what's interesting here is when he talks about, when you say 25 and 26 are kind of set in stone and we don't question it, but then ours is a living constitution. Ours is a moving constitution, it's a living constitution. That's what makes it different. So if we were to set everything in stone and use the definition of essential religious practice, and I understand the reason why it's been put there, but then I think going forward is going to be very difficult for women, for lesbians and bisexuals, for homosexuals, for all of this. I think these rights were originally not envisaged I mean, what if some essential religious practice believes homosexuality to be the worst thing ever, right? And is that protected under 25 and 26? So I think in a moving constitution, Articles 14, 19, 21 in some ways have to be more essentials than the other.
And
I feel that as a layperson.
It's quite interesting, because hearing you talk about this led me to just quickly go, right? There's that society plays a huge role into some of these changes. Coming back to Calcutta and West Bengal, the whole practice of Shindur Khelo, right? It's moved away from just the married women. And I think it's to all women, and it's moved away from just the married and unmarried women, even to men and transvestites, so who largely live lives of women. So it's very fascinating because, and I am a firm believer that the development of law in any country, especially a country like ours, has a symbiotic relationship with the changes that we are witnessing in society. Tons has been written about it. I think 377 judgment would not have come, and I'm sure Chandar would agree, if it was maybe a decade or two earlier. So we're evolving. You talked about a living and a breathing constitution. A couple of quick things, and Doc, you talked about this, and I want to use this as a platform. We have a hard stop in 10 minutes for the role of media. So in the Idgah slaughter case, you say something which is, again, quite telling. You say that this was clearly an issue of cleanliness, an issue of cruelty, but regrettably today, it would have most likely been mischaracterized as a conflated religious issue, an issue of Hindu Muslims. And that is a sad moment in the recent developments in our republic. So I don't think there could be a better way for us to end this with this. And then my last question is going to be the role of media in some of the decision making. But love to hear your thoughts on this, Doc.
Well, time is short. I think the right thing done, even if you say the right time, but in the wrong context, will always be misunderstood. The context has changed. I don't want to talk politics on this program. And the context and the ambience, if they change, every right thing is liable to be misunderstood. And the misunderstanding and those who misunderstand would not be wrong, because they have been tainted by 7, 6, 5, 10, 20 years of suspicion, doubt. So therefore, that is what is happening. Now, Idgah, the way it started was by a magistrate. I mean, it was literally rivers of blood in the location which is in the heart of Delhi. It has nothing to do with vegetarianism versus non-vegetarianism. It has nothing to do with community A or B. It was located at a place, those of you who have seen where the earlier Idgah was, is unimaginable. So all that was done was that a very modern abattoir was made with machinery and all, and in distance, and the same thing was being relocated. But there was a huge outcry. So I think it required a PIL, and I was privileged to have done it. But you know, you are absolutely right. Today it will be misunderstood. I don't think it will be wrong to misunderstand it. The problem is that I don't think it will be, although I will think that it's a wrong understanding. But the problem is, why have you created an ambience where that wrong understanding will arise in almost everything you do?
And it's fascinating because in this case, you know, you were presumed by the Jain community to be arguing this case on account of your own beliefs as a Jain, as a practicing Jain. And yet you articulate and state in your book that you put your religious beliefs aside and told these clients of yours that I'm not going to push the issue of banning, because what a person eats is their individual right. So for some
I was approached by the group which specifically asked me to argue banning of rights in the Idgah matter. And my written submissions say that I'm putting it on hygiene, environment. The principal arguments were put on the environmental basis. And I think that is the right way. I mean, I can't impose my vegetarianism on you, and therefore there's no reason to do it.
And Chandar, I want to end this. Mahua, this has been great because we really haven't seen one of those debates that we were all hoping to see from your days in, you know, your parliamentary debates. But Chandar,
let's say I say boost to certain denominations.
I can assure you that would have been much more exciting also, by the way.
I think it's the cool breeze in London where Mahua presently is that may have been had an impact on cooling things down. But Chandar, I really want to, Dr. Singhvi talks about at 2 places in the book, one in the context of, or actually 3, the Sabarimala case, where he says that there was an immense pressure from the media as regards the standards that were set. He says also that Justice Malhotra's dissent was hugely criticized in the media, especially because it was a view and an opinion of a lady judge to ban women. And then he says exactly the same thing, which led to the second review in the Jallikattu 2, where he says that the glare of the media, let me rephrase that. He says that it was courageous to pass a judgment of this sort despite the media glare. So I want to understand from you three, as we wrap this up, on the role that the media is playing on some of the judicial decisions that are happening. We had Mahua talk about this, the famous statement, there are no migrants on the street. What is the role of the media, and any concluding remarks, please?
So I think very shortly, it's that today the level of media attention is something which we, when we started out our practice, we could never have imagined. In fact, judges in the Bombay High Court, for instance, Justice Bharucha or somebody would probably issue a contempt notice if something got reported on when the case was being heard. Today, every conversation in court, every utterance of the judge gets reported, even if it's a totally prima facie view, etc. And there's a deluge of media because it's on your mobile phone, it's on television, it's on in print, it's everywhere. It's all around. It's on WhatsApp, forwards, and
so your view, is that a good thing? Is that a bad thing?
So I think the pressure on judges must be immense, must be much greater than they've ever faced. On the other hand, the discovery of lies, the discovery of subterfuge, the exposure of things that now, when the Supreme Court was told and glibly that there's no migrants on the road, and the Supreme Court accepted and said we close these cases. Right after that, when Barkhadat hit the roads and when several others hit the roads, and television, I mean, clips showed up and print showed up and the actual reality showed up, the Supreme Court was on the back foot. They tried to do some face saving, and then ultimately they made good. They actually came. It is like Der Aay Durast Aay, but it was late. It was definitely late. But for the media, it wouldn't have happened at all. The government would have got away with the cover up.
I won't let you dodge this, but is the minutiae reporting in the press a good thing, largely for the profession and the judiciary, or especially when we're talking about things like live streaming of court? Just one word, good, bad.
Personally, I think, I follow the old, I forget which judge it was in Britain who said that judges are made of sterner stuff. I believe that judges are made of sterner stuff, and they can, they can read and follow the media and yet form their own opinions and so on.
Thank you.
But I think on balance, the fact that you are able to discover things is more important than the opinion thing.
Sure, no, absolutely, Mahua. And as a parliamentarian, in some ways, live law, bar and bench, legal reporting, on any given day, you'll open a front page, there are 4 or 5 stories from our courts. It's giving you a ringside view, right? It probably makes you feel that you're in the trenches. So quick closing thoughts, because the last word from the doc after this, please.
Yeah, I think on balance, I would tend to agree with Chandar saying that judges are made of sterner stuff, so they can withstand the pressure, or they should be able to withstand the pressure. You don't get to the bench if you don't. And it's like us. If you get elected, then you can't have a thin skin. You can't. I mean, if you're 1,543 in a country of 1.3 billion, you can't make excuses. Just suck it up and chin up. So I agree with that. But on the other side, there are so many things as a citizen that I come to know, and not just as a litigant, but even if it's not in my case, the fact that bar and bench on the Twitter feed, literally every line, even if it's a sigh of exasperation, that is reported in that. And I actually like that, because when you think of the migrant case, and the court itself was put under pressure and they had to come up with something. Now, for example, this entire sealed envelope stuff that has been going on.
right? This entire sealed envelope. I do think in another year or so that there will be no court that will be willing to accept the sealed envelope thing just because of the media backlash and because of not so much the media backlash, but of backlash from civil society being reported by the media.
Sure.
So I think, it helps us all know. So for example, when the Solicitor General stands up in court and makes a ridiculous remark, and I know about it instantly, I can react to it instantly.
Sure.
And I think that to me makes me a better, more informed citizen.
And, last word, sir, Doc, as India's, sorry, go ahead, Chandra, because I do want to have Doc have the last words.
I have something to say from a person who is in the trenches, often in the opposite trench from Manu. And this I want to share. This is not from the book, but this is personal. I think I have to tell your audience that to me, one of Manu's greatest traits is the fact that he never gets personal. He never attacks his opponent. Never. He's one of the most amazing opponents to have. He'll fight tooth and nail for his case and his cause, but never, the level of courtesy to his opponents is just mind-blowing. And that hasn't come in his book because he's not going to say it. So I have to say that.
It's really, really kind of you. It's very overwhelming. It's really overwhelming.
Before, and it's fascinating, right? Because I remember having this conversation with Doc during the lockdown. What's equally fascinating about him, which Rohan talked about in his introduction, India's top lawyer, spokesman for his party, third-time elected parliamentarian, often found on TV, loves time for his music, and it's just amazing, fascinating. I reached out to him saying, sir, how do you manage your time? It's remarkable. A man who's got absolute paucity of his time, he just manages to do. He really is the example of stretching his 24 hours into 48. So Doc, as the moderator, all I can say is, I'd love to hear your last words, and my only parting comments would be, can't wait for the next 20 cases in your next book. We should keep Satyajit ready.
Thank you so very much. It's really overwhelming. You're making the person who's speaking in court and out of court all the time speechless by embarrassment. Now, I think, of course, there's been a book about us and they've called me in that book a multitasker. Multitasking has always been the bane of my life. It has also been the joy of my life. It's been a great learning curve. But I want to end very, very, very quickly, we are way out of time, on this last point of media. There is an inquisitorial aspect of media, which I fully support. But the migrant case inquisitorial, these are rare examples. There is a second aspect of technology, the platform of the media. Nobody can deny it. It's fantastic. But the question is about the effect of the media on the judicial, adjudicatory, or other systems. I think it's a very negative impact in the last 7, 8 years, 10 years. I think that the compulsion to conform, this I've written about many years ago also, it's nothing new, but I think it's my own theory. The compulsion to conform, namely the compulsion we feel to say what we believe the media wants us to say, is a very dangerous ethic, which negatively influences more than anybody else judges. Being of sterner stuff is good in theory, Chandra. In practice, you and I know that a lot of that sterner stuff doesn't exist. Now, today, therefore, the worst impact of this is in pure criminal law. Criminal law, as we were taught when we were students, doesn't lie anymore, and that especially in the superior courts, because they are decided by the compulsion to conform. I will decide the bail by thinking first what the media will say if I decide this way or that way. There are several other areas, high-profile political cases. Merits take a backseat because I am influenced by the compulsion to conform. In fact, I believe that a person as flippant and as superficial and hollow as Donald Trump, succeeded in the US because he transcended the compulsion to conform. He was blunt to the point of being ridiculous, but he did not conform. Today, the biggest chilling effect on free speech is not censorship. The biggest chilling effect on free speech is our own internal compulsion to conform.
It's fascinating you say that, Doc, and I know Samir, we're out of time, but just a couple of minutes. It's fascinating you say that because it dovetails into what we were discussing about the role of media. And with our common neighbor, Mr. Soli Swarajji, I remember talking to him on one of the evenings during the lockdown, where I asked him this question about the reporting in media about court proceedings. And he said something to me which is quite telling, and I wish some of our journalists would follow that. He said that even if the cases are reported, they should be attributed to the court and not to the individual judge who is delivering the verdict. And that might go a long way, Doc, in this compulsion to conform. We're completely out of time. Thank you so much, Rohan. Thank you, Samir. Thank you, Chandar. Mahua, I can't wait for a more charged up discussion, inshallah, sometime soon. And thank you so much, Doc. I know it's Friday tomorrow and conferences beckon for miscellaneous days.
All these busy people,
Thank you so much. And thank you to our
Thank you.
audience. Sorry,
Thank you for a very riveting
Thank you.
discussion.
Thank you, Scotch Group. Thanks very much.